Hello there, and welcome to my channel. Today I want to talk about something a little bit different than what I normally cover here, or what I normally used to cover here when I was regularly making videos. I used to talk a lot about science and that kind of stuff. I'll probably do some more videos along those lines one day, but today I want to talk about the law. Specifically, I want to talk about the recent Supreme Court case, Dobbs v. Jackson Women's Health. That's the case that overturned Roe v. Wade. And I want to talk about a mystery I see regarding that case. Now, if you think you know what mystery I'm talking about, what might be mysterious about Dobbs v. Jackson Women's Health, you probably don't. I haven't heard anybody else mention this, but I want to talk about it. And you, whoever you are watching this video, I hope you'll tell me what you think is the answer to the mystery I'm going to be presenting. So a couple of things you should know about me at the start of this conversation. One is that I used to be an attorney, but I am no longer practicing. I may practice again one day, but I am not practicing right now. And so I'm going to be talking a little bit, not about specifically the practice of law, but about some things that lawyers think about when analyzing a case and whether a case should be taken to court. Another thing you should know about me is that I am pro-life, always have been. Now, you don't have to be pro-life to understand what I will be talking about with this mystery here. It's awesome if you're pro-life. If you're not, you will still understand what I'm talking about, and you won't disagree or find it offensive. At least not most of what I say. So, please, once you've watched the video, tell me what you think is the reason behind this. So anyway, Dobbs was a case dealing with a 15-week abortion ban. Abortions were largely restricted after the 15th week of pregnancy. If you have been following the subject, you may know that most abortions actually occur before the 15th week, and that internationally, this is actually not an unusual law. Lots of countries, including very liberal European countries, have much stricter laws regulating abortion than a 15-week ban. So I wanted to talk a little bit about the way these Supreme Court constitutional rights, civil liberties cases typically wind up before the Supreme Court. Now, most of the time, they don't come organically. So somebody doesn't decide to appear before the Supreme Court and challenge a law. And they go to a lawyer and they say, hey, I don't like this law and I want to challenge it. Usually these cases come about because an organization, an activist organization, will cultivate cases. They'll look for the right plaintiff with the right circumstances, somebody who will be really sympathetic. And they will look to take these cases to court at the right time, to be before the right judge or judges or justices, people who are likely to find the case sympathetic and are likely to find in their favor. Because usually if a case is going to court, especially if it's going to a high court, it's something that there are arguments on either side, so it could go either way. So lawyers usually want to make sure they have the best chance of winning these cases. And to take something to the Supreme Court, it's going to involve lots of lawyers, it's going to involve lots of work, it's going to involve a lot of money, which is why these cases aren't usually organic. It's usually organizations with deep pockets. Now, in this case, the plaintiff is an abortion provider, I believe. So this is an organization with fairly deep pockets. It may have happened organically, but even if it did, any lawyer that had this potential plaintiff with this potential law, this potential case come into his or her office and say, hey, we want to try to overturn this, should have had a really long and serious conversation with that plaintiff. Because And this is the one part that if you are pro-choice, you probably won't like what I'm about to say. But regardless of your perspective, what I'm going to say is true anyway. Abortion is not actually a constitutionally protected right. It was a Supreme Court protected right. It does not occur in the Constitution, and the only way it is protected by the Constitution is if the Supreme Court looks at the Constitution and says, yeah, I think abortion is protected here. There have been lots of very good attorneys who were pro-choice, including the famous Ruth Bader Ginsburg, who did not like this decision and came out publicly and said, this is a bad decision, this is bad law. So people who wanted to uphold this law have really been depending heavily on having Supreme Court justices who are sympathetic to their side. That's why every time there's a confirmation hearing on any new justice, whatever their political affiliation, whatever, there is always a lot of discussion of abortion and Roe v. Wade, because all it takes is a group of justices who don't look at the Constitution and say, okay, we're going to insert this here. We're going to uphold a right that is not actually in the Constitution, that is not even indicated in the Constitution. We're going to decide it's there anyway. So it has been in a precarious position for a long, long time. In the 50 years that it has existed, it has been in a precarious position. So anytime you have a case go before the court talking about abortion, if you don't have a very liberal pro-choice court, there is a good chance you're going to lose. And there is even the chance that Roe v. Wade and subsequent cases are going to be overturned. Now, in this particular case, I did not think Roe v. Wade was going to be overturned. I don't know what percentage of current practicing or former attorneys or just the general public thought this could happen. I didn't think it would happen, but I also didn't think it was an impossibility. I just thought it was an improbability. But I also didn't expect that the Mississippi law restricting abortion after 15 weeks was going to be overturned. I thought Roe v. Wade and Casey, the main case coming after that, would be weakened, would be restricted. There would be some exceptions carved out, something like that. The court would still find that the 15-week restriction was reasonable, and that they would permit it to stand without actually overturning Roe and Casey. But, again, it was possible. And looking at this court, this was not a court that was likely to be sympathetic to the position of the plaintiffs here, the people who were trying to overturn this law. It was a case they were almost certain to lose. The only real question was, how badly were they going to lose? So when they went to the attorney, their first attorney, their second attorney, whatever, were they told, yeah, you're going to lose this? You may win to start with. The lower courts, whatever court you first take this to, the lower courts, they're going to be on your side because they're going to follow the existing precedent. But the Supreme Court does not have to follow the existing precedent. They are able to overturn their own precedent from history. And if you take it to the courts, it's very likely it's going to wind up in the Supreme Court, and it's very likely you're going to lose. So the mystery is, how did they wind up prosecuting this case? How did they wind up taking it to court in the first place? A clearer way to say this is, what was their reason for taking this to court knowing they were going to lose? Because they knew they were going to lose. And they did it anyway. What do you think? Tell me below. Until next time.